Hello, and thank you for joining us on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of the Greater Toronto Area family law firm, Feldstein Family Law Group. We have offices in Markham, Vaughan, Oakville, and Mississauga. Today, our special guest is Barry Kaufman. He's a sole practitioner whose office just happens to be down the street from mine in Markham. And Barry is a very experienced lawyer in real estate, mortgages, estates, wills, powers of attorney, and he does some corporate and commercial law, and he's been doing that for over 40 years. And I know a lot of my clients have used Barry, and I give them a very strong recommendation. And as a lawyer who has extensive experience handling real estate matters, Barry is here today to speak with us about selling the matrimonial home and how that process is being impacted by the current pandemic. Without further ado, Barry, welcome to the show.
Thank you for having me, Andrew, and thank you for endorsing me as well, too.
Well, it's really my pleasure to have you, and it's probably been long overdue.
It's always nice to speak with you.
So if you can start by telling us some of your experience in the area of real estate law and your general approach about handling real estate transactions that involve divorcing spouses, because obviously it's a little more complex than the average transaction.
It's important to make my role as a lawyer in a real estate transaction where parties are separating or divorcing absolutely clear. I send my clients a letter and I set out what my obligations are to be. Those obligations are, first of all, to make sure that the sale of the property closes. In that part of the closing of the transaction, I pay any existing mortgages, charges, liens, encumbrances, tax arrears, as is sometimes the case, utilities and commission expenses, and any other costs relating to the sale of the property. The net proceeds of the sale will be divided between the parties if there is a written separation agreement. If there is no written separation agreement, I refer my clients to independent counsel so that they know what their rights are and whether they're entitled to part or a greater part of the net proceeds of sale because of child support obligations, other family obligations, or that there would be an unequal division of the property. Should the parties be in a protracted disagreement, I will hold the net proceeds of sale in trust, and depending on the length of it, I'll put the money into a guaranteed investment certificate so at least the money is working for them. I do make it clear to my clients as well too that I'm not there for the purposes of settling any matrimonial issues that exist between the parties.
So let's start with what I always think of as the first issue. And I think you gave us a lot of information in that answer, so thank you. But the first question I always get is one side typically wants the house sold and the other side doesn't want the house sold, or sometimes they both want it. But when they do, my clients come to me and they say, well, what's going to happen? Because if I sell my house, I need somewhere else to live. And I think what I heard you say, which is consistent with what I think the general approach of the bench and bar is, unless there is some sort of an agreement, the monies are going to be tied up in your trust account.
That's correct, Andrew.
And that's something that's really critical that people need to understand, because if you sell your home, it doesn't mean that you're necessarily getting the net proceeds of sale on closing when you're separated, unless you both agree to a payout. And if you don't both agree to a payout, then the monies are going to be frozen, subject to a court order.
That's absolutely right, because I'm not in a position representing both vendors, both sellers of the property, to make the determination how the net proceeds of sale should be split. What the parties need is some type, excuse me, of a separation agreement so that the money can be paid according to that separation agreement. And if there is no separation agreement, then they can go to council, and perhaps some type of a temporary agreement can be worked out between the parties so that they have some money to carry on their daily lives. I would not recommend that anybody who is selling a house and is in the midst of a separation or a divorce purchase another property, because they're placing themselves under a great deal of pressure to be forced to settle a claim with a spouse, and they may find the settlement of that claim to be somewhat unfair. The spouse who doesn't need the money or who is not buying the property may say, well, it's not me that's under pressure to complete a transaction. It's you that's under pressure to complete a transaction, and use that as leverage to make an unfair bargain for one of the parties.
Well, that was very well said, because that's a common problem we see. And in fact, when we get hired by clients, we regularly send them some do's and don'ts. And one of the don'ts is don't go buy another piece of real estate, because just like you said, it puts you in a position of weakness. And you can't assume just because your half of the proceeds may be a significant amount that you're going to have access to it. And that's why you shouldn't be buying anything.
That's absolutely correct.
Not only that, the court process is slow and protracted, so I may not be able to get that order that a client wants for the release of some money fast enough in order for them to close on their subsequent transaction.
That's right. And if they do buy a property, if they have decided that they're going to buy a property, and they're relying upon the net proceeds of sale, or what they think is the net proceeds of sale, based upon whatever agreement or whatever arrangement has been made between the estranged spouses, they may find themselves in a much worse position, because the standard agreement of purchase and sale provides that time is of the essence, which means if you've purchased a property, you have to close by that date. And if you don't close by that date, you are in breach of the agreement of purchase and sale. And the consequences, it can be disastrous as well too. You may lose your deposit. You may be sued if the property is sold for less money than it was sold to you at. You can find yourself responsible for interest on somebody else's mortgage. That would be the seller's mortgage. You can find yourself responsible for taxes, for utilities, for insurance, for maintenance, for upkeep. You can find yourself also liable to pay legal fees and disbursements. And of course, you'll have your own legal fees and disbursements to defend an action if one is commenced against you.
So this is why when a client comes to me and they say, Andrew, I want to get my house sold, my first question to them is typically, let's assume you get none of the proceeds of sale. Where are you going to move to? Where are you going to live? The most common answer I hear is people are moving in with their parents. And if they're able to do that, then it's fine to move on to the next stage about selling the home. Now, the backdrop of that statement is that the threshold to force the sale of a home is actually very low. The way you can resist it has to be for a claim for exclusive possession, and you can't be frivolous or vexatious in forcing the sale. So in more cases than not, on an interim basis before trial, the courts seem to be inclined to sell the homes because they know that also forces people to settlement. There's nothing like having $1 million sitting in somebody like your trust account, Barry, to make people want to resolve a dispute because they both want to get their hands on their money. But the practical reality is that a lot of times the house will be sold and you need to plan for where you're going to go on an interim stage on the assumption that you're not going to have enough money to go buy something. And I think it's really important for people to understand that particular issue will come up in almost every case when people are involved in a family law proceeding. Now, I'm going to take it.
That's a very good point, particularly where there are children that are involved, and their interests have to be considered as well too, such as where they're going to go to school, who they're going to be with. They're also facing the trauma of divorce, so it's a very good idea to raise that issue with them right away.
Now, have you seen, we're currently in the pandemic, have you seen a change in the way transactions are being closed and what's taking place in the real estate market in light of the pandemic?
Well, addressing the issue of the real estate market, from where I sit, I see that the real estate market has slowed down quite a bit from where it was before the pandemic. Before the pandemic, in January and February, and up until it really surfaced into public consciousness, the real estate market was fairly brisk. It was a fairly active market that we had. But since the pandemic, it slowed down much more than what it was before. And with respect to how people are purchasing and selling properties, it's becoming progressively more difficult. A property is it's the biggest investment that most people will make in their lives. And it's the type of thing the type of article that you like to go out, you like to see it, you like to examine it, you like to feel it, you like to know what it's going to be like to live in a property. Well, that's difficult to do when sellers aren't inviting you into their house to see the property, to view it. And the only way to view it is through virtual viewing of it. So it has slowed down the real estate market quite a bit. And it's also had the impact of making it more difficult to be a purchaser of a property as well, unless you're really brave and you'll buy the property just on the basis of the virtual pictures that are provided to you as well. Another issue as well too, it's very common that people want to know what kind of property they're getting. Are they getting a solid property, or are they getting a property which is going to require a lot of maintenance and repair? So they want to have somebody inspect the property, and very often offers are conditional upon the inspection of a property. The problem is right now, home inspectors or engineers are no different than anybody else. They don't want to enter into a place where potentially they could be infected with COVID-19. So that's another issue to consider as well too.
Well, I can say
your choices are somewhat limited as well right now too, because there aren't open houses to go into as there used to be. So all those factors are having an effect upon the real estate market, certainly.
Well, I know I've had a couple of cases where we've had to have homes listed for sale. I've seen one actually sell, and I found it interesting because I saw special pandemic clauses that were included in the offer to settle, because it's my understanding right now, transactions are still closing. That if you're scheduled to close on, say, May 15th, you can't use the pandemic as a reason not to close the transaction. Is that right?
That's absolutely right. The pandemic is not a reason for refusing to complete the transaction. If you try to refuse to complete the transaction on the basis of the pandemic, it's a breach of agreement of purchase and sale.
But what I did see in the one deal that I saw consummated were some pandemic clauses in case that changes and you can't close, that we're trying to deal with it. And I'm assuming that may be a more standard kind of clause, that if the land registry office isn't accepting or land titles office doesn't allow you to register the deal, then you have to have some mechanism to extend the closing.
Yes, and the mechanism would be possession of the property to the purchaser, retention of the balance due on closing in the trust account of the vendor solicitor.
Okay, so
But that hasn't happened so far because the land registry office is still open, and we register today electronically, unlike the old days where you had to go down to the land registry office, exchange documents, stand at a wicket, and register your ownership and your mortgage to the property.
well, the real estate system in Ontario is far more advanced than the family law system, because we're still doing things for the most part just like it was when I became a lawyer in 1994. If you want to file materials, you go down to court and you file your materials.
It doesn't sound any different than when I became a lawyer in 1980.
I see we have a question that's for you, which is, can closing be done virtually via Zoom?
Yeah, and the simple answer to that is yes, it can, provided that proper identification is provided, and provided, of course, that you're witnessing your client sign all the documents.
Now,
and I've started to do that as of late, and it's been approved from the Law Society of Ontario as well, too.
Now, the thing that I find interesting, because I've seen some people have to move because they were tenants and their leases came to an end and the landlords were moving back in. But despite all the other challenges that you described, such as not being able to see the property that you're looking at, which is to me a significant challenge, not being able to have it inspected, just picture having to move during COVID-19. Because that's a challenge in of itself, because now you have to pack up all your belongings. You're most likely going to hire a mover, which means you're going to have somebody who is touching all of your possessions, all of your property, in order to then go into your new home. So that's another challenge. I mean, the best piece of advice that I'm giving clients right now is, if you don't have to sell, don't. But
I would agree with that advice, certainly. And there's another consideration with regards to that issue as well, too, and it's the market itself. Bear in mind that COVID-19 has discouraged purchasers from buying properties. So that means if there are properties that are out there for sale and you're expecting one price, but you're not getting any offers on the property, that it can result in receiving a much lower purchase price for a property than it would otherwise fetch in a normal market. I recently had one of my clients who unfortunately made a mistake of purchasing a home back in about February or so, before the pandemic set in, and they purchased the property and they were relying upon the proceeds of sale to complete the purchase. Most unfortunately for them, they had one price in mind. They had to drop the price $300,000 to sell the property. That's a fairly dramatic loss to incur on the sale of your property, particularly when you consider that you are losing after-tax dollars as well, too.
Well, I guess that person is one of those stories that you hear about whenever you sell a home, and I should say, whenever you buy a home before you sell your home, that you're worried that intervening few weeks or a month may be the wrong period of time. And that story you just told is a perfect example of that.
Yeah. Yes, it is. Very much so.
I remember when I sold my last home, I bought first and I was scared until I sold my home that the market would correct in the middle of it. So that's why some people say it's better to sell your home first and then buy, because you're not going to get caught. But the problem is sometimes you have an upward market and the opposite is happening.
Markets can and do change overnight. The change that I'm remembering, the most recent one, was around April the 21st of 2017, when the Non-Resident Speculation Tax Act was enacted, and the market literally stopped overnight. Prior to that enactment, the market was sizzling, and people were purchasing their houses on the assumption that they would have no difficulty in selling their house. Well, of course, that didn't turn out to be the case afterwards. They suffered losses. It still is possible to purchase a property before you sell it, provided that you look at the economics of the situation. And the economics of the situation are, how much of a debt, if any, do you have against your existing house? Are you able to extract the equity, in other words, your ownership interest from the property, the net proceeds of sale you would otherwise receive through mortgaging that existing house, or a combination of mortgaging the old house and mortgaging the new house? It means that you'll be carrying two properties for a period of time until you sell one or the other. Presumably you're looking to sell the old property. That's why you purchased the new property, but it can be done as well too. It is, however, though, generally for most people, particularly where you've got a mortgage and you don't have a substantial amount of equity, or you don't have a source to turn to, like a family or reserves on hand, as most people don't have, you can find yourself in a very uncomfortable position.
Okay, so to sum it up, there are some people in this current market who are in an unfortunate situation. They feel compelled to sell their homes because they had bought something else and they need to liquidate their assets, and they don't have any ability to raise funds in any other fashion. And that unless you really need to sell, I think you're saying, don't do it right now. Wait for the pandemic to come to an end and wait to properly list your home, with the caveat that we aren't real estate agents and we can't predict what's going to happen in the market.
No, we can't forecast. We're not soothsayers. We don't have a crystal ball in front of us to know what the market is going to be, most certainly. And this is certainly not the most ideal time for selling property.
I would agree with that. Generally speaking, what are the steps involved in selling a matrimonial home?
The steps involved are essentially the same as selling a property when the parties are not quarreling with each other. You list the property for sale at market value, and it's sold pursuant to pretty much a standard Toronto real estate agreement of purchase and sale, and the transaction is completed. The difference is, though, of course, that there may be a question, there may often be disagreement over how the net proceeds of sale are going to be split.
Well,
and in the ordinary transaction, it's always a good idea to have a copy of the tax bill, so that when the property is listed, you know what the taxes are, or if you're in a condominium, to know what the maintenance fees are as well too. If you're in a detached home and you have a survey of the property, that may also be useful, although title insurance covers what a survey would otherwise reveal. And it's a good idea as well too to know what the penalties are, if any, if you have a mortgage on the property. If you can gather that information together, then chances are it's going to be an easier transaction for you.
And when are you usually involved in the process?
I'm usually involved at the point where the offer is firm. I am often involved as well too when the property is conditional, when it's conditional upon financing, when it's conditional upon inspection, are the most common conditions that I see, and I'm involved with that as well too. I like being involved at that point because it gives me an opportunity to review the agreement of purchase and sale and make sure that there aren't any clauses, that there aren't any paragraphs in there which are harmful to my clients.
Well, it's interesting because obviously I'm involved earlier in the process, and there's typically a lot of disagreements that can take place leading up to the sale of the home. The first one is typically, are we going to sell it? And then if you agree with that, then we get into the potential disagreement of who is going to be the listing agent. Am I picking one? Is my former spouse picking one? Or do we have a co-listing where two agents are there? And then the next problem that we regularly see is, what improvements need to be done to the home to ready it for sale? Are they minor cosmetic or are they more significant? And there's typically arguments over who's going to pay and how much in order to realize on the greatest dollars. And sometimes you have somebody tries to delay the sale by saying there has to be significant improvements and fighting about how much it's going to cost and how long these improvements are going to take. These are all problems that probably happen before they get to you, Barry, but I assume sometimes you see that in the accounting of who gets paid out of the proceeds of sale, that somebody wants to get their money back for paying for improvements as soon as possible on closing.
I do see that on occasion as well, too. And you're right, you're involved with that before generally I'm involved with the sale of the property as to whether there'll be improvements to the property, as to whether somebody will be compensated because they've had to move out of the property and had to find alternate accommodation.
And ironically, the last fight we usually see during the course of the sale, if we've agreed on the real estate agent and agreed on the improvements and the house is being listed, is sometimes parties will have a disagreement over who the real estate lawyer is, because one side feels more comfortable knowing who's holding the proceeds of sale in trust. And that can be part of the overall negotiation process. We're even seeing some people say, I get to pick the agent, you pick the real estate lawyer, or vice versa.
Yeah, that can happen on occasion as well, too. And the parties that are separating, that are divorcing, are welcome to retain counsel for themselves, to have individual counsel. In other words, you'll have two lawyers that are involved in the sale of a property, and the documents will be prepared in one lawyer's office. They'll be sent to the other side's lawyer, and those documents will be signed in the other side lawyer's office. That can happen on occasion where there's a bitter disagreement between the parties and nobody trusts any lawyer except one that they've chosen.
It's rare that happens, because even when there's distrust, there's usually motivation by saving the cost of not wanting two lawyers and two real estate agents. But every so often, it does happen. And it's regrettable that the lack of trust is the way it is, but that's regrettably part of family law. Barry?
Unfortunately, it is a part of family law. If the parties are acrimonious enough, and they absolutely hate each other, then yes, it may be necessary to retain independent counsel for each one. It doesn't happen often. A real estate lawyer who's acting on a sale of a matrimonial home is neutral. The real estate lawyer is there for the purposes of transferring title to the property, paying the mortgage, the taxes, the utilities, any other expenses associated with the sale of the property. And that's all that they're really there for.
Okay, Barry, I wanted to thank you for joining us on the show. The time's gone by very fast, and it was a pleasure having you. The next Ask Andrew show is June 15th at 1 p.m. And if you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you so much for watching.
Thank you. Have me back anytime again. I'd be glad to speak with you, and I'd be glad to answer any viewers' questions.